notice, and it is further appearing that on May 2nd of 2025, said defendant was previously convicted of violating MCL 750.356D in Eaton County. Therefore, this violation of statute constitutes retail fraud in the first degree. This is a felony that is punishable up to 5 years and/or $10,000, or 3 times the value / difference in price of property stolen, obtained, or attempted to be obtained, whichever is greater. To impose a fine of 3 times the value, the defendant must admit the amount, or it may be determined, or must be determined by the trier of fact at trial. See case law. Court may order reimbursement to state or local government for expenses incurred in relation to the incident, including but not limited to expenses for emergency response and prosecution per statute. Count 2, police officer assaulting, resisting, or obstructing. On or about September 2nd, 2025, at 6200 South Pennsylvania Avenue, Lansing, Michigan, 48911, Eaton County, State of Michigan, the defendant did assault, batter, wound, resist, oppose, or endanger Summer Hayes, a police officer of the Lansing Police Department, that the defendant knew or had reason to know was performing his or her duties, contrary to statute. This is a felony that's punishable up to a maximum of 2 years and/or $2,000. Consecutive sentence may be imposed under MCL 750.506A if the assault was committed in a place of confinement, or under MCL 750.81D6 for another violation arising from the same transaction. Court shall order law enforcement to collect DNA identification profile sample before sentencing or disposition, if not taken at the time of arrest, and against the peace and dignity of the state of Michigan.
Sir, did you understand what was just read?
Yes, Your Honor.
So you understand count 1, retail fraud, first degree, is a felony punishable by 5 years and/or $10,000, or 3 times the value or difference in price of property stolen, obtained, or attempted to be obtained.
Yes, Your Honor.
And count 2, police officer assaulting, resisting, or obstructing, is a felony punishable by 2 years and/or $2,000.
Yes, sir.
And restitution can be requested for any personal or property damage or loss. Do you understand that?
Yes, sir.
And if you dispute any amount requested, your attorney will ask for a hearing, and then I will make a determination on the amount. The amount can go up, it can go down. You understand all that?
Yes, sir.
All right. And sir, during this event, were you high or intoxicated?
Yes, sir.
Okay, and so I'm going to be asking you questions to make the factual basis. Do you remember these events or not?
Yes, sir.
All right, counsel, you believe that to be true?
Yes.
Very good. All right, sir, it looks like you signed the advice of rights form. Did you read it before you signed it?
Yes, sir.
Did you understand what you read?
Yes, sir.
If you had any questions, your attorney was able to answer those.
Yes, sir.
Do you have any questions about your rights of this court?
No, ma'am.
Sir, as to count 1, retail fraud, first degree, how do you plead?
Guilty, Your Honor.
As to count 2, police officer assaulting, resisting, obstructing, how do you plead?
Guilty, Your Honor.
And do you understand that by pleading, you're giving up your automatic right of appeal? If you choose to appeal, you first have to ask permission of the Court of Appeals to appeal, and now it becomes their decision whether or not they take up your case. They will only take up your case if they think your issues are important. Do you understand that?
Yes, sir.
And you understand you're giving up other important rights, such as the presumption of innocence, holding the people to their burden of beyond reasonable doubt, the ability to cross-examine witnesses and evidence, the ability to request the court to bring forth witnesses you want, etc.
Yes, sir.
And do you understand that if I do not follow this agreement to have the sentence run concurrent with Eaton County, then I would allow you to withdraw your plea, and this matter would again go to the pretrial stage. However, if you violate bond conditions or the law between now and sentencing, I don't have to follow that, and I would not allow you to withdraw your plea. Do you understand that?
Yes, sir.
Has anyone told you what I will do at sentencing, other than the plea agreement?
No, Your Honor.
That's the right answer. It sounds like a question, but that's the right answer, not a trick question. And the reason is because I don't know much about your case. At the time of sentencing, I'll be informed, but I certainly have no idea what I will do until sentencing. Do you understand that?
Yes, sir.
All right. Did these offenses occur on or about September 2nd, 2025?
Yes, sir.
In the city of Lansing County, Bingham, State of Michigan,
Yes, sir.
at a specific location known as 6200 South Pennsylvania Avenue?
Yes, sir.
And is that the Meijers?
Yes, sir.
Did you enter it when it was open to the public?
Yes, sir.
And did you take items with the intent of not paying for them?
Yes, Your Honor.
Were those items offered for a sale price of $200 or more, but less than $1,000?
Yes, Your Honor.
And were those recovered in a saleable condition?
Yes, Your Honor.
And what were they?
Some clothes, cut some food, just some household items.
All right, and then as a result of that, at that location and day, officers came in contact with you, is that correct?
Yes, Your Honor.
And did you resist arrest?
Yes, Your Honor.
And you understood they were in uniform,
Yes, Your Honor.
performing their duties?
Yes, Your Honor.
And what did you specifically do?
I refused to be handcuffed.
So did you fight with them?
I did, yes, Your Honor.
So that struggle would endanger not only you, but officers and possibly people around you, is that correct?
Yes, Your Honor.
All right. On behalf of, well, and let's just make sure you were, and the retail fraud is first degree because you had previously been convicted of that same offense on May 2nd, 2025, is that correct?
Yes, Your Honor.
All right, and so that's why you have that enhancement.
Yes, Your
On behalf of the people, are there any additional questions,
The people are satisfied, Your Honor.
counsel?
No further questions.
Thank you. Our counsel or promises, threats, or inducements other than those already placed on the record?
No, Your Honor.
No.
Does court comply with the court rule?
You have, Your Honor.
Yes.
I find defendant's plea has been freely, voluntarily, knowingly, and understandingly made without undue influence, threats, coercion, or promises of leniency. I also find there sufficient grounds to accept defendant's plea. Therefore, counts 1 and 2 will enter. Counts 3 and 4 and the habitual second are dismissed in their entirety. Any outstanding warrants related to this file are also recalled and dismissed. Do we have a sentencing date?
May 27th at 10:30.
Well, Your Honor, just like, please for a moment. Thank you, Your Honor.
All right, and sir, I just want to ask you, you pled of your own free will,
Yes, Your Honor.
and no one forced, threatened, or coerced you to plea, and you've been satisfied with the representation of your attorney?
Yes, Your Honor.
All right, sentencing will be May 27th at 10:30. Does that meet with your schedule?
It is, Your Honor. Thank you.
All right, now, if we need to move that, I just want to make a record, we can move it so that we understand what Eaton County is doing if needed. If you don't know, I don't know what the issues are going to be, but since this is to run concurrent.
So you would, what you're saying is you'd prefer that Eaton, we sentence him probably first, or?
I prefer that you at least have the plea. I don't know what, I don't want to run afoul of the agreement. So, and I don't know what their scheduling is. And so,
So if we need more time, again, yes, I understand, Your Honor.
okay, so plea or sentence, I just want to have the information so that I don't run afoul of that without knowing, and then we're back here again. I like one-stop shopping. So,
Exactly.
does that make sense to you, sir?
Yes, Your Honor.
Okay, now probation is going to come and see you, call you, I don't know, Zoom with you, I don't know how they're gonna do that, you're in Eaton County, I leave that up to them, but they will be contacting you because we're going to have a pre-sentence investigation report done. I can't go to sentencing without that, so I need you to fully cooperate in that. Now, over in Eaton County, are you participating in substance abuse treatment? Are you going through any classes at all?
They don't really offer anything.
Yeah, they don't need.
That's just wrong. I thought Eaton County had some good programs.
They have rap, that's it.
And he can't get in rap ice.
No, that's a probation thing, yeah.
Yeah, so,
Yeah.
all right,
That was, but the only thing I had for the record, Your Honor, was last time we were here, he pled guilty to a bond violation. I don't believe, I didn't hear the court set a bond on his, a new bond for his case, or if the court was setting one. That was Mr. Graham's only question, was if there was a bond set in this.
let me see what we have for bond. Well, why would I have bond if he's going to serve likely a prison term on the other file?
I understand, Your Honor. We just wanted to make sure, I wanted to make sure, if in my notes, what the court had actually said.
I actually don't know, but I'm gonna revoke bond so all your time counts. I think that's in your best interest, sir, because you're not gonna get out on bond because of the Eaton County. So I think what's in your best interest is revoking bond, having all your time count, and these will all run together. So I think unless you tell me otherwise with the bond motion, with the bond report, that's gonna stand.
I understand, Your Honor.
All right, thank you. That's all for the record. Good luck, sir.
A defendant walked into a Meijer store in Lansing, Michigan, high according to his own admission, and walked out with clothes, food, and household items he had no intention of paying for. When officers caught up with him, he didn't go quietly. He refused to be handcuffed. He fought. In uniform, on duty, officers struggled to bring him under control. A moment he admitted could have endangered not just himself, but everyone around him. What made this case more than a simple shoplifting charge was the defendant's history. Just months earlier, in May of 2025, he had been convicted of the exact same offense in Eaton County. That prior conviction is what elevated today's retail fraud charge to the first degree, a felony carrying up to 5 years in prison and fines reaching $10,000 or 3 times the value of what was taken. And add to that a second felony count for assaulting and resisting a law enforcement officer, and this defendant was looking at serious consequences. Before Judge Rosemarie Aquilina, he entered guilty pleas on both counts. The judge accepted them, finding the pleas freely, voluntarily, and knowingly made. Counts 3 and 4 were dismissed. Bond was revoked, so every day already served counts. Sentencing is set for May 27th, and the judge made clear she doesn't know what she'll do until she does. That's how it works. What this case reminds us is simple. Patterns matter in courtrooms. Prior convictions don't disappear. They come back, and they come back harder. If you found this case as eye-opening as we did, hit that like button, drop your thoughts in the comments, and subscribe for more real courtroom breakdowns, because justice never gets old.